Good evening, everybody. Jonathan Ginsberg here, and I have a special guest, my friend Greg Brinkley. Greg is a former Social Security disability claims manager, claims adjuster. What do you call it? I guess, what's their exact term? I always mess it up.
I had a lot of them, but I was in the DBS as a claims, I was a disability analyst.
And disability analyst, so basically making the decisions about whether people qualified or not. And Greg is a resource that I rely upon when people have the questions that I don't have the answers to, like a lot about CDRs and about continuing disability reviews and termination matters and things like that. So I get a lot of questions about that. So I thought that, it'd be useful to and interesting to have somebody like Greg on who can really talk about what goes on the inside in Social Security. So let's go to look at some of the comments. So I see Christina, hello from California. And by the way, tell me, I think everybody should be hearing me correctly. I've got my microphone on. It is relatively close to me, so that's working out. But anyway, let me know if, in fact, I'm going to go here just to kind of look at this in the in live, and just to make sure that we are going live here, that it is actually working, and it seems to be. Okay. All right, so anyway, we're going to go ahead and just take some questions. Well, actually, before I do that, Greg, I know you, but tell them what you did for Social Security, for how long, and kind of just your overall background, if you could.
Sure, Jonathan. I was involved in Social Security disability programs for 27 years. I started out as a disability analyst. I moved up to a senior analyst, worked on all kinds of every claim that you can think of in the DDS I worked on.
DDS is the Disability Determination Services. These are the folks that make the decisions at the initial application and reconsideration, not at the hearing. So this is pre-hearing, the two levels for pre-hearing. So just to define our terms. So I'm sorry, I didn't interrupt, but go ahead.
Oh no, you're good. I'm glad you brought it up, Jonathan, because we didn't do hearings. We did do assistance requests for the hearings. We didn't work on the claims.
Okay.
We also handled CDRs, EXRs, all of the CDR level claims. I moved on to disability fraud. This was all on the state level.
Okay.
And then I went to the federal government and worked in the regional office in Richmond, California, in the disability processing branch, which is the federal DDS. And I became a technical expert, a team leader. I was a senior team leader. I was over the fraud processing unit, fraud prevention unit in San Francisco, which are only 3 in the entire nation. I was a team leader over that. And then from there, I worked in the field office for a couple of years. But my whole work was Social Security disability.
Okay. And one of the things you mentioned, just so people understand, you mentioned that you worked at the state level, then at the federal level. Can you unpack that a little bit so people understand why the state they live in would be involved in a federal Social Security matter?
Yes. And I know someone said there's an echo. I'll try to fix that in a moment.
Okay.
But just to answer the question, some states are backlogged, and the federal DDSs provide backup support for the states in the region. So, for instance, in California, the regional office is in California, but they assist DDSs at the state level in Washington, Nevada, Arizona, Hawaii, I believe Oregon. So in every state in the region is managed by that regional office. So when it comes to claims that are backlogged at the state level DDSs, the federal DDSs help out with those cases.
Okay. And the states, as I understand it, they work under contract at initial and recon under contract with the federal government. So even though you're applying for Social Security disability, which is a federal program, Social Security is a federal law, the states, the state agencies, and they're known by different things. In Georgia, it's DDS. I've seen it disability DDD, DAS. There's all kind of different names. Some states have completely different names, but we refer to them as a state agency, and these are state employees who work under contract with the federal government, unless the federal government offices that what Greg was talking about might have to step in and help out So there's sort of a combined effort between the states and the federal government to administer Social Security disability. Is that a fair way to put this?
You're absolutely on target.
Okay.
The federal offices do what's called a professional services agreement, a PSA, with the state, with the DDSs directly to assist them.
Okay. All right. So let's go into some of the questions. And 11T9 times 3 says, will back pay come all at once or do they spread it out? And do I have to report that in taxes? For SSDI, the back pay comes in a lump sum. For SSI, I understand that they pay every 9 months? It's broken down into three installments. Am I correct on that? I believe it's 3 installments. I'm not sure how often they come, but if it's an SSI lump sum, it's not all at once. And that actually gets people rather upset. In fact, I've got a case right now that we won the SSI case. It's 20-something $1,000. And my client is really unhappy because they're only going to pay him a third now, and he's got to wait 9 months to get the rest of it. I'm guessing that's because SSI being means tested, if you get this lump sum, they figure it's going to take you 9 months to go through it. But if they paid it all at once, you would have too much in terms of assets to qualify for SSI. So it's kind of backwards in my opinion, but they make people wait all that time. And then they have to wait even more. But for SSDI disability, the lump sum is paid at once. For SSI, it is going to be paid in 3 different installments. Okay, Big One says, hi from Texas. Hello, Big One from Texas. Glenn says, I had my PERC SSI interview. That is PERC, is income and resource. Is that right? I'm not sure. What does PERC stand for? Do you know? I'm not sure what that even stands for. PERC. It's income and resources is what it is. Yeah. Any idea when I'll get my benefit letter, back pay, and monthly payments? And again, I will tell you, having dealt with this, in fact, I called a DDS office yesterday about this. When somebody has a concurrent case where they have both SSDI and SSI, 2 different offices have to process the claim. So the SSDI processes it, then SSI has to process it. And many times, because SSDI offsets SSI, you won't get any SSI, you'll only get SSDI unless you're getting SSI for the 5-month waiting period. Again, we can get into all that, but bottom line is that many times there is no SSI, but they still have to go through the process and decide that you're first entitled, then you're not entitled. And what happens many times, people get 2 letters, one that says you're getting money, and then the next day, oh, by the way, you're not getting money. My experience has been if somebody has an SSI, a concurrent claim, that is going to delay the processing of their SSDI and SSI because you have 2 different offices that have to kind of coordinate. So it'll delay it. In my cases, I'm getting favorable decisions and the money's arriving within 3 weeks. For concurrent cases, it can be 6 or 8 weeks. So it definitely takes longer. Okay. Cancer-free, and I hope you are cancer-free. I've been diagnosed with severe COPD and emphysema today, was put on oxygen, 58 years old, have no income, and I qualify for SSI and SSDI. I'll give my answer, and Greg, you can tell me what you think. First of all, you don't win based on a diagnosis. So a diagnosis of severe COPD does tell us that there's probably symptoms that do limit you from functioning, but the diagnosis alone, unless it is at a listing level, is not going to generate an approval. The fact that you put on oxygen tells me it's very, very significant. You don't get put on oxygen unless you've got something really, really going on. You're 58 years old, which says that you're probably not going to be able to do light work. So that says to me that there's a grid possibility here, grid 202.06 in particular. And if you've got, limitations that impact any transferability skills, pain, anxiety, things like that, you very well may grid out. So I would say, based on what you're telling me here, there's a decent chance that you're probably going to have a pretty good argument. Greg, what's your take on it?
Yeah, I agree with that. I think there is a good chance if you are on oxygen, if you are O2 dependent, then your chances are really going to be increased, because even if you had to do what's called a pulmonary function test, I think the PFT will actually show your the readings, the FEV1 and the FVC are going to be pretty low. And if you're O2 dependent, it's really a good chance that your ability to sustain work is going to be compromised. It doesn't mean that it won't be totally, because some people can work
Hmm.
with an oxygen tank and just carry around, have it on wheels. So that is possible. But with your respiratory issues, there could be enough to say, even on an RFC, hey, he cannot be exposed to fumes and odors and gases, and
Heat or
even
cold, maybe.
exactly,
Yeah.
exactly. So, and then there could be some tolerance issues where it could affect your ability to stand, sit, walk,
Yeah.
and even lift, especially lifting. So,
Yeah.
so I think there's going to be uh, a really good chance for you to get on, especially like Jonathan said, with your medical vocational profile being 58 years old.
Yeah. Yeah.
20206, depending upon your education, it could be 20206, could be 20204.
Hmm.
Just with the light RFC, the light grid.
Yep. Yep. Well, the thing is, I mean, I think that, and the grid rules, by the way, generally speaking, are designed for people with physical limitations. And one could argue that breathing problems are not a physical limitation. It's not your back or your knees, but breathing limitations are going to limit your capacity. I mean, if you have to use an oxygen tank, for example, you're not going to be climbing ladders or ropes, scaffolds. You're not going to be probably walking, 6 hours a day. You're not going to be lifting 20 pounds. So even though it seems like a breathing problem would not necessarily be exertional, it really can be. So I think that is why the grids would apply. And the second thing is, if you look at the grids, and let me share my screen real quick here. Let's see if I can do this correctly. Like grids, okay. So this is the grid rules here, and we talk about, let me make this a little bit bigger here. We talk about 202.06. So if you look at 202.06, it basically says if you're limited to a light exertional capacity, again, standing and walking 6 out of 8 hours, lifting 10 pounds frequently, 20 pounds on occasion, you're a high school grad or more, but you don't have direct entry into skilled work, and you have no transferable skills, you are disabled. So what if somebody, let's say, has a skilled job, they were I don't know, let's say they were an executive secretary, or they were doing something where they had skills, they're a respiratory technician. Ironically, that would be, they might have skills, but if you have severe anxiety, if you have, depression that are associated with not being able to function anymore, if you have panic attacks because you have problems breathing, these things would reduce your skill, your transferability of skills, to the point where essentially it is, unskilled work. So you can, even if you have transferable skills, we can get rid of that by identifying some of these other problems that you might have, migraine headaches, severe nausea, things like that, take away from your ability to focus and concentrate. So even though the grids technically talk about exertional capacity, there is many times a non-exertional component in it. In addition, there is something, the Social Security has some rules in what they call the POMS, Program Operational Manual. I'm not sure what POM stands for. Program Operational Manual, which basically says that at age 55, if you're limited to sedentary work, the transferability of skills has to be almost where you go back to exactly what you were doing. You're not going to be able to necessarily do something even similar. It's got to be almost exact, very little vocational adjustment. And at 60, if you're limited to light, again, very little vocational adjustment. So we always talk about that the older you are, the more likely it's going to be that you're going to have an easier time meeting the grids. I mean, the grids kick in at 50. Actually, they kick in, a couple of them kick in even younger, but for the most part at 50. But at 55, that's when the sweet spot is. That's when you really have an opportunity to prevail in the grids. So when you were at DDS, did you use the grids frequently to analyze cases? Was that something that you were trained to do?
We lived
or
on
is
the
this something
grids.
that some adjudicators don't really understand?
We lived on the grids.
Okay.
lived
Okay.
on. That was something that was a regular occurrence because when you get to sequential evaluation steps 4 and 5, we already have the grids in mind when we get the case, because we're trying to think of what will it take to allow.
Mm-hmm.
And once I know that the person may be in line for an allowance if they get a light RFC, then I know how to approach my case. I know how to write up the case to the MC. And
Let me stop you because you're using abbreviations. I know
Thank you.
as a Social Security person, you live with acronyms. So let's make sure that we translate into English for the rest of us. All right. So
Okay.
an RFC, that stands for residual functional capacity, and it's just like it sounds. That is your capacity for work that remains, the residual part that remains. Let's see. It's just okay. There we go. That is the part that remains after you factor in all of these other issues. So that's what an RFC is, and that's a legal determination that Social Security will make about what your capacity is. Okay, so that's what that is. Then you used another abbreviation. What was it? Is it MC?
The medical consultant.
Okay. Who is that?
The medical consultant is the doctor on staff in the disability office with the examiners. And they are responsible for doing the medical analysis of the evidence because they are certified, board certified doctors who are working in those offices.
Okay. Are these typically retired doctors? Are they people in current practice? Is it just to make a little extra money? What's your sense about the quality, the training of these doctors? Who are these people?
I've known a lot of them over the years. Some are retired annuitants, which mean they're retired, but they are back in working on contract with Social Security inside those offices. Some are in private practice still.
Okay.
So it varies. But the quality of MCs in general are pretty top notch. They go through a pretty rigid screening process to determine whether they should even be working on these cases based on their expertise.
Okay.
And there's different medical specialties at the DDSs in those offices.
Okay. And I assume that do they physically go to the office, or is it done remotely and they do it part-time? I mean, give me a sense of that as far as how the doctors work. Just because the reason I'm asking is because processing times are getting longer and longer. And so at one point I sort of had this vision of, doctors coming to the Social Security office and spending 8 hours, churning through files, but I don't get the sense it really works like that.
Well, once upon a time, when I first started, the cases were paper.
Yeah.
I'm sure you remember that. Yeah.
Oh, yeah.
So we actually had to walk the case over to the MC's desk and put it on the shelf or in the basket. Now they're in an electronic environment. Everything's done through the case processing system in those offices, and they route them to the MCs that way.
Okay. And one more question about the grids. And, I was just talking about how, the transferability of skills analysis has got to be part of it unless the person is, basically has no transferable skills. Does that trip up adjudicators? Because and the reason I'm asking is I've had adjudicators say to me, well, your client can't meet the grid. He had a skilled work background. And I try to explain, well, yeah, he may have a skilled work background, but because of these other issues, the anxiety, depression, those transferable skills really don't exist anymore or really can't be utilized anymore. Does that explanation, do people understand that? Or is that something that sometimes the adjudicators don't necessarily understand it?
To just be quite honest, Jonathan,
Yeah.
I would say roughly 70% of the analysts who are in the DDSs do not do thorough transferable skills assessments.
Okay. Yeah, I mean, and look, it's not an easy thing to do, and I'm not criticizing for it. My point is that when I sometimes will talk to a potential client or a new client, I'll say, I think we've got a good grid rule argument here, and I'll make that argument when I do the application or the recon, and say this is why the grids apply, even though this person has skills, they don't really transfer because of these other issues. Sometimes I get the feeling I'm whistling into the wind, that doesn't really resonate as much. Judges get it, but I suspect that, again, part of it is, look, I assume that as an adjudicator or claims person, you are you have a certain amount of leeway to make judgment calls. I mean, obviously, you're relying on the medical experts to help you decide whether somebody meets a listing, but beyond that, there's a certain point where your portfolio is to let the judge deal with that. That's not something that somebody at the DDS would do. Is that a fair assessment?
Well, what should be happening is the examiner, the analyst should be doing that work to determine if the skills are transferable or not.
Okay.
The only problem with this is the level of attention to detail by the analyst, the individual analyst, on whether they are going they're going the extra mile to really look at that, and then cite policy to make the case more bulletproof in the event that DQB, which is the Disability Quality Branch, picks up the case and reviews their work.
Got it. And I guess I suspect a lot of these analysts are really, really busy. I mean, I know that's one of the things that new commissioner is talking about a lot. And he spoke at the NOSCR convention in Nashville a month ago. They don't have enough people. And so I'm guessing that these analysts are just overwhelmed with work. And, at some point you just, they're being asked to, deal with people's missing social security cards and man the phones. And then they're also asked to, do analysis of disability cases. I don't think it's necessarily the matter they don't want to. It's just they don't have time. And what happens when we don't have time to do something? Just say, well, just move it along. Let somebody else deal with it. So I suspect that's part of this too.
Well, yeah, it's a contributing factor. I think there has traditionally been a percentage of workers who just don't do the work thoroughly enough. And when I was a team leader, I reviewed cases. I reviewed the inline reviews of the work done by those analysts. And I had to send those cases back and say, hey, this is not going to pass through the quality branch if it gets picked up. You need to do an analysis. And when I trained analysts, I said, you need to have a vocational explanation for every case. It needs to have that level of detail. And like you said, right now, it may not be a priority because they're being slammed so hard.
Yeah. As an analyst, when you were doing it, you obviously dealt with the DOT, the Dictionary of Occupational Titles. How did you deal? Because I know at hearings, judges always ask the vocational witness, they recognize, they'll say in the record, we know the DOT is outdated by 40, hadn't been updated in 40 years. So I want you to rely on not just, the DOT, but your own experience, expertise, knowledge, and so forth. At the adjudication level, the state agency level, how do they deal with that? Because do they have vocational experts there to help with vocational analysis?
They don't technically have vocational experts in the DDSs. What they will have is a vocational specialist. It could be an experienced analyst. It could be someone in the operations branch inside the office who is doing that granular level of analysis on the vocational issues. So it's not really something that is across the board in those offices, but some do have those people who are experienced enough and who may have gone through some vocational training to equip them to do that.
I mean, I guess my big picture point is that at the administrative law judge level, you have judges who can address some of these inherent flaws in the case evaluation process, the age of the DOT and the inapplicability of some of the jobs, the question of transferability of skills. And I suspect that at the state agency level, the analysts are somewhat hamstrung because they don't necessarily have the authority or the resources to know how to deal with some of these kind of structural problems that really need to be addressed. But that's at a different pay grade, I guess. So that's just my thought.
Yeah.
All right, so let's we're getting some backlog of questions. Speaking of backlog, so let's go to this. All right, Eric Campbell says, I got great news today. I'll tell you after you get going. It was all because of the help. Oh, well, thank you very much, Eric. I'm glad I was able to help. And, I don't know what I did, but whatever it is, I'll take credit for it. So that's cool. That's excellent. Okay, Brian. I noticed some money to deposit my account from Treasury prior to I received it. Yeah, okay, so what Brian is talking about is, and I know exactly what he's talking about here, is Social Security approved this case, but they've not sent the letters out. And no, the letters have not always gone out, and sometimes there is a disconnect between the letters going out and the money being paid. It's not a bad thing to get a bunch of money in your account. I would tell you don't spend it until you know that everything is correct. But how does that happen very often, to your knowledge, Greg, or is that just one of these things?
Well, it can happen if the mail is delayed coming out of the field office, or if the workload support unit or another office processing those claims once the determination has been made.
Yeah,
there could be a delay in the mail, and in some cases, they may have done the non-medical review and really did it quickly, where they could effectuate the payment and the lump sum back pay right away.
I know you just used a term, and people ask about this all the time. What is a non-medical review in a SSDI, Title II SSDI case? What is the non-medical review?
Yeah, that's something that happens when they file the application, and then it happens after the determination. So there's actually two. So once a person files an application, they're going through a non-medical review to see whether they are earning above substantial gainful activity, and their citizenship is in line, and the things that are potentially snags in a person being able to pursue the claim any further. Then when the case comes back with a decision, usually an allowance, then they do the same check, because something could have happened in between the first one and the determination.
Yeah, and I always assumed it was because, Social Security doesn't necessarily get the earnings record right away, so they always ask you for, your work history to make sure that let's say that you filed taxes and the tax return for 2023 shows your earnings. Well, we're now in July of 2024. What if you worked, from, pick a date, November of 23 through the present, you may have been working. And so even though you qualify medically, you've got earnings over SGA, and that would require additional inquiry. Let's put it that way. Yeah. Okay. All Motors says, I wonder if All Motors from Detroit, the Motor City, who knows? My ALJ hearing is on October 22nd. Looks like I got a good judge. They have a 65% passage rate. Yeah, that's good. I mean, the hearing, there's, and I think I've given you all this, there's a number of places you can look up judges and the approval rates, and some of these are more outdated than others. But yeah, 65% is pretty good. I think nationally it's maybe 48, 49%. So if you have a 65% judge, you're in good shape. In fact, I did a pre-hearing call today with a client. We have a hearing next week, and it's 68% approval. Doesn't mean we're going to win, but better than getting an 18% approval rate judge. And I think that's one of the things, by the way, that really frustrates me about Social Security, is that you could have the same case, identical case. Person A gets judged 18%, person B gets judged 65%. It's a lottery. That's not really justice. I mean, whether you win or not, it just depends on which judge you get. And that just seems unfair. I've often wondered why, some enterprising attorney doesn't challenge, file an appeal on the grounds that the judge's approval rate's so outside the standard deviation that they're not getting a fair hearing. No one's done that, but that to me would be, especially some of these judges, there's a couple of them that, 5%, 8%. I mean, that's ridiculous. I mean, if nationally it's 48%, a judge that approves with a substantial number of cases approving 8 or 10%, that says to me there's a problem here, just as it would say to me there's a problem for a judge that approves 85% or 90%. That's probably too high. So, but again, that's to leave it for another day. Okay. Okay, so, and Cancer Free says you have enough credits to apply, says I have 40 work credits. Okay, so again, what he's getting at here is that SSDI, you have to have a certain number of credits to qualify for Title II disability, and they've got to be recent. That's something. Let's talk about that a little bit. People sometimes say, I got a call a couple weeks ago from a woman who had been working, and she was, I think, in her 50s, and had worked for many years, in the private sector, and then the last 15 years worked as a teacher for one of those school districts that does not, that opted out of Social Security and was paying into some sort of a teacher's retirement system. So she didn't have enough credits. She had enough credits for retirement, but not for disability. Greg, tell me about that a little bit. How the, your understanding of how the credits work as far as disability and the recency part of it. Well, it's got to be current.
Yeah, you are right. It is dependent upon what you have done in the recent past, and there are a couple of exceptions, but you need 40 credits for retirement, but 20 for disability, 20 in 10 years. But the thing about, and this doesn't get talked about very often, Jonathan, and that is when you have a situation where a person was insured at some time in the past.
Mm-hmm.
And as a result, they could actually file a claim based on that prior disabled insured period.
Right.
So we call those DLI in the past cases. And that's something that doesn't really get a lot of publicity, but and I've dealt with some clients who've had those situations that say, hey, you can still apply.
Mm-hmm.
We just need to be able to know if you can get records to establish that you were disabled before that window ended. Yep. And you can still put in a claim for that.
Yeah, and again, just to kind of, explain, take that a step, just to unpack that a little bit. Example would be somebody worked for a period of time, they stopped working in 2016, let's say. Generally speaking, their insured status will follow them for about 5 years because, again, you've got to work for 5 out of 10 years. So their date last insured for Title II disability will be 2021. We're now in 2024. If they apply for benefits, they've got to allege an onset date before their insurance runs out. So that would need to be in 2021 or 2020. Now that can be, I can tell you from my end, that can be very, very difficult to prove you were disabled at a level of to meet Social Security's requirements 5 or 6 or 7 or 10 years ago. It's a real uphill battle, but it can be done. And, I've also had people tell me that when they apply, they don't understand when to use it, what to use as an onset date, and the adjudicator may say, well, just use today. Well, no, you can't do that. You've got to really know. So, and the hard part is that you look at your My Social Security statement, it does not tell you when your insurance ran out, your DLI or date last insured. You've got to kind of calculate it a little bit or kind of guesstimate. And sometimes people call me and I'll look at their statement and we can kind of figure out when it might be. But the point that Greg's making is that if you have not worked in 4, 5, 6, 7 years, your onset date needs to be going back to a point where you're within that window where you were insured. But keep in mind that a remote date last insured, and a remote onset date is much more difficult to win. And if you do win, in terms of back benefits, you can only get paid 1 year prior to your date of application. So you may prove you were disabled back in 2018 or 19, but you're not going to get money going back to 2018 and 2019 if you applied in 24. So, there's a lot of moving parts there, but the point here is that if you think that you became disabled, many years ago and you, for whatever reason, didn't apply until just, recently, you've got to really think about the onset date you want to use, because otherwise, if you don't choose the right onset date, you'll be told you don't have enough credits and you're out of luck. So,
right. Hey, Jonathan, one more thing.
Yeah.
In terms of a person trying to find out when they are insured, I did a video, actually it was my first video on YouTube. And what I tell people is call the National 800 number or your field office and ask them to do a DISCO query.
DISCO query, okay.
Yeah,
All
and
right.
that will take less than a minute for them because it's usually accessible on their desktop,
Okay.
on their laptop. They can just do a quick query. It will tell you exactly when that window starts and ends, the date first insured and date last insured. And the most important date is the date last insured.
Yep. And that's DISCO, like a disco tech.
Disco ball, discotheque, yeah.
Okay. Okay. So I'm just going to put that in the comments. And we see those in the files, the exhibit files that we work with, preparing for hearing. But you can, as Greg says, you can call up and ask for the information in a DISCO query. Okay. We have another question here from Ms. Super Clean. My wife would like you because my wife is a neat freak, so she likes super clean everything. Please elaborate about mental RFC form to be filled by a psychiatrist. Is there a difference between that form and a medical questionnaire? I don't really like to use the term mental RFC because RFC is a thing. It's a legal determination, but an FCE form. In fact, I found a couple of places, and I'm going to share my screen, so I'm going to show you where you can get free forms. And let's see, there we go. Okay, there is a website here, an attorney named Mike Merberg. I don't know Mike, but he has on his website a RFC forms. He calls them RFC forms. So there's a whole bunch of them here you can download if you want. They're free. And, again, some of them may be a little outdated, but they're obviously very, very helpful. And I think I'd shown everybody before. There's another, let me see if I can go to this one here. There's another place here you can get them, and I showed this last week, and that is on the How to Get On site here, where you can look at sample functional capacity forms. So there's a couple places you can just type in sample RFC forms or sample residual capacity forms, either on Mr. Merberg's site or on this How to Get On. So they're available to you if you want. And again, when I'm doing a case, I'll make my own. I have my own forms, and I may customize them. But if you're doing this on your own and you want these forms, there's nothing wrong with using one of these standard forms. It's probably helpful. Now, as far as the difference, I think it's just a matter of terminology. Medical questionnaire, again, it's got to address vocational issues, reliability issues. So the FCE forms that I just showed you, they're typically going to reflect those factors. A medical questionnaire, that's a generic term, so it really depends on what's on that questionnaire, but they're out there. Even if a lot of times, we can't get them because the doctors won't do them unless you want to pay them. Just the medical records can be enough in some certain circumstances, but you want to ask your doctor to address the vocational issues that you are facing. And let me ask you, Greg, when you were looking at files, how persuasive was an FCE form? How persuasive was one of these quote unquote RFC forms when you did your analysis?
Well, when we're talking about the FCEs or even the medical source statements or MSS forms, it really depends upon whether there is supporting evidence. Because some analysts would send a case to the medical consultant and say, hey, I got an MSS form by this person's treating source. That's all fine, but there's nothing to support it. Even if the doctor wrote something on the MSS, some comments, or the FCE, that still isn't enough. It's not supportable by itself. So
there's got to be underlying records.
The underlying records, or even if there is a summary letter from the doctor, that could actually be supported because they kind of go into some more detail on a treatment history, recent physical exam, their prognosis. So there's still context there as opposed to just a standalone form.
Yeah, and I will tell you, having done many, many, many hearings over the years, judges can disregard an FCE form or RFC form if there's no underlying medical records, and they will do that. So I've had situations where, somebody has gotten a doctor to fill out a form, but there's no treatment records. That person never treated with the doctor, or there's no evidence they treated with the doctor. Pardon me. Yet some doctor filled out a form and said, "Oh, this person is disabled," or the doctor who did treat them filled out the form talking about the severe disability. But if you look at the records, it talks about mild impairments or no impairments or maybe medication-seeking behavior. So, the form is great, but it's got to be, in addition to underlying records. So the form, I look at forms like these functional capacity forms as a way for a doctor to translate medical findings into specific vocational limitations. And of course, disability is about vocational capacity. So the more you can line up the translation or the limitations being given with the underlying medical record, the better that's going to be.
Jonathan, one more thing, if I
yeah.
could, to deal with the question that Mr. Superclean is asking. If we're talking about a medical questionnaire being the MDQF, the Mental Disorders Questionnaire form, then that would be an excellent form for the doctor to complete, because it goes into the history of the present illness, it goes into the mental status exam, it also talks about their function. So that would be a valuable one for the psychiatrist to complete, rather than just an FCE or an MSS.
Okay. And where would one get an MDQ? Tell me the abbreviation again. I'm just going to.
MDQF.
Okay.
And Jonathan, I'm going to send you one.
Okay.
Because I have it, and you can make it available to whoever needs one.
Okay. Excellent. We'll post it on the show notes here. Okay. All motor notes that you need to have extremely bad arthritis to get approved. And this raises a bigger question, and that is, in my experience, and tell me if you agree or not, Greg, the more common conditions like arthritis, like diabetes, like depression, you've got to have a level at a much higher level, because SSA sees so many of these conditions. So osteoarthritis, everybody gets it, for the most part. So if you're going to win an osteoarthritis, it's got to be pretty severe, as opposed to, a 3 herniated discs or something like that, where, it is almost by definition a disabling condition. The gentleman who asked us before about needing oxygen, that's at a different level. But a common condition like arthritis, diabetes, depression, you've got to have something more than just your sort of basic, mild to moderate. Agree or disagree?
Absolutely agree. Arthritis will always be number one on the hit list. On the charts, it'll always be number one. Depression will be number 2 in the charts. It's not even close. So with arthritis, you're going to need to meeting a listing for arthritis is
almost impossible.
It's such a high bar, because you have for listing 115, you have to have 4 criteria to meet.
Yeah, no, it's in fact, I'm going to show that because people a lot of times will say to me, hey, I meet the listing here. And I'm like, no, you probably don't. As much as you might, I'm not disagreeing that you are disabled, but I mean, here's listing 1.15 in particular, disorders of the skeletal spine. And I've got a website called metalisting.com. You can go there and see it. Oops, going the wrong way here. But you can see, I mean, it is to meet this, you've got to be almost non-functional. I mean, this is one of the more difficult ones, and they've made it more difficult over the years. So this is, literally a documented need for a walker, canes, or bilateral crutches. Inability to use one upper extremity to inability to initiate, sustain, and complete work-related activities involving fine and motor gross movements. You got to be a real mess to meet listing 1.115 or most of the musculoskeletal listings. So, what Greg is saying has been my experience as well, that arthritis, which is what this is going to fall under, they make it really, really hard to meet. And diabetes, for example, they used to have a diabetes listing. They got rid of it. Now diabetes is part of other listings. And so, you've got to show the symptoms that are really, really severe that maybe cause neuropathy or retinopathy, the underlying problems. So it's really hard. Depression, again, same sort of thing. It's got to be debilitating. And I always give my indicia of severity with things like depression, suicide attempts, inpatient hospitalizations, multiple medication changes, lack of success with medications, treatment-resistant depression. They make it really, really hard to win on these more common type of conditions. Very, very difficult. All right, so you've got, looks like a fan here, fingerprinting gurus, and he basically says, "Oh, so we got a number of fans here."
Yeah.
Okay, well, obviously, it's always good to be known. Calvin wants to know how you're doing. Okay.
Doing well, Calvin.
Okay. Do you think the Supreme? Okay, now this is I was not expecting this, but I'm glad that JTLBZ says, do you think the new Supreme Court ruling on Chevron could affect Social Security? Let me just give you a Reader's Digest version of what this says. Is basically the Chevron doctrine, and I'm by no means a Supreme Court scholar, so there may be people on this live stream who know more about this decision. This is, taking me back to con law and law school. Basically, you have the Congress, which is a legislative branch, and you have agencies like Social Security, Federal Trade Commission, SEC, all these different agencies. And so Congress, being dysfunctional as it is, and busy, they basically say, okay, we're going to make a law, Social Security law, and we have this agency over here that they deal with this stuff, 7 days or 5 days a week. That's all they do. So we're going to defer to the agencies to make rules and make procedures and policies. Even though these are legislative decisions, we're going to basically, give that authority to the agencies, and that's called the Chevron doctrine. Well, the Supreme Court just a few days ago in a case, and it was I can't remember the strange facts, had to do with some like a fishing case or something. It was really weird. But the point is they basically said, the Chevron doctrine is not really such good law, that we think the legislative branch, the Congress, has been giving too much power to these agencies, and that some of the agency decision making, needs to really go back to Congress. And this is a major issue because every agency out there has this huge bureaucracy of people that make rules, and Social Security being no exception. You have all these different rules and procedures and just, the way the whole system works. And if, people start saying, well, wait a minute, the agency does not have the authority to do that, it's got to be done by Congress. Well, everything goes into chaos. So right now, we don't know exactly what's going to happen, but I think what we're going to see is that, agency rulemaking, Congress is going to have to figure out a way around it where they can delegate it and it comes back and it has to be maybe affirmed by Congress. There'll be some way they get around it, but, there very well could be some challenges to some of these agency rules that cannot be delegated from Congress. So the Chevron decision or the new Supreme Court ruling that limits or reduces the Chevron decision could be very important. We don't know what's going to be yet, but yes, very interesting question, and we're all kind of waiting to see. A couple of years ago, there was something similar that happened where the authority of Social Security to appoint judges was called into question, and I filed several appeals on the grounds that the judge was not properly appointed, and Social Security, the appeals council, remanded all those back. And basically, they had to sort of reappoint the judge to make it kosher, as it were. So that may be the same kind of thing that goes on here. But it's an interesting legal question. Again, I suspect that they'll come up with an answer to it, fairly quickly. But yeah, it's a very interesting question. And kudos to you, JTLBZ, for knowing what it was and to even ask it. It's a very interesting question. Have you heard anything about this Supreme Court decision at all?
No, I haven't. That's above my pay grade.
Yeah, okay. Let me see if I can get you the site.
But it sounds interesting. And,
yeah.
To your point, Jonathan, I think it's just going to, like you said, throw everything into just chaos and mayhem.
Yeah. The case, by the way, if you're interested, is called Loper Bright Enterprises versus Raimondo. or the Loper case. And basically, the Chevron decision was back in 1984. And so, it's basically this one invalidated some conservation regulation. And I think what it had to do with was fishermen had to have certain type of specialists on board to make sure they were following rules about conservation or something to that effect. It was basically going to put a lot of fishermen out of business, I think is what it was about. And so somebody challenged it. So this Loper case could have some real significant implications. And the way the Supreme Court works is they made a decision in this case about this agency, but what everybody's going to do is going to say, well, it applies to other agency, because the way the Supreme Court wrote it was basically saying that Chevron is no longer a valid law. So that's kind of what's going on. So it'll be interesting to see, but again, I suspect they will they'll figure something out. Okay. D.D. Partlow says, is it a bad sign when the ADJ, maybe adjudicator, I don't know if I assume that's what they mean, says they're waiting for my follow-up from my carpal tunnel surgery. I'm 58, have spinal stenosis, Parkinson's, and severe depression and anxiety. I don't think it's a bad sign, assuming she means adjudicator. What do you think, Greg?
No, I don't think it's a bad sign either. I think it could be a situation where they're waiting for the results to find out. Well, one, they're trying to find out your response to treatment, how you recover from the surgery, and what kind of function that you're left with as a result of the surgery.
Mm-hmm.
And also, they're likely also trying to establish duration to make sure that your impairment is continuous. And we don't know exactly how long you've been dealing with the carpal tunnel, but if it's been longer than 12 months, then it would mean duration already.
Yep.
But then it would get into the response to treatment.
Yeah. I mean, my sense is that the adjudicator is probably wants to make a complete file, and having that carpal tunnel just makes the case even stronger. So again, it passes muster under the quality review.
Mm-hmm.
All right. Rodney is a loyal former client of ours, and we appreciate him tuning in. Thank you. And hello, Rodney. Daryl asks, how much can I safely make each month after being on SSDI? And I get this question every week. It's a legitimate question, Daryl. And, I'll give you my answer. Let's see if Greg has a different one. Basically, there are two things you got to be concerned about. One is called the trial work period, where I think it's $1,110 a month, and you have 9 of those in any 5-year period of time. You can make as much as you want. You can make $10,000 a month. You can make $100,000 a month, and doesn't affect your benefits at all during that 9-month trial work period. Once you use up the 9 months, and I think they give you even a grace month, but let's just keep it at 9 months, then you get into the territory where substantial gainful activity becomes an issue. In 2024, SGA, or substantial gainful activity, is $1,550. So as long as you don't make $1,550, you are okay. You're not exceeding the amount. The question that I always get, and Greg, maybe you can tell me, first of all, tell me if I'm right on my analysis there, but
Absolutely.
More importantly, if somebody is working and they're earning $1,549 every month, is that going to be something that's going to be suspicious that might trigger a review?
No.
Okay.
Yeah, because they're going to be looking at, well, I'll say this. When you apply for SSDI, they're going to do that work, have you complete a work activity form to figure out what your earnings are and if you're under that threshold. And they're also going to be considering whether you have what's called a subsidy, which means that the job makes some kind of accommodation for you that can be quantified in some dollar amount to bring your earnings lower to get you under that threshold. And there's also what's called an IRWI, an impairment-related work expense, like if you need medicine or if you need special equipment.
Big monitor, maybe a big computer monitor, or a special keyboard.
Yes, things like that require you to have to come out of pocket to purchase these things on a monthly basis. They can use that to reduce your earnings under that threshold. So those are two things to keep in mind as well.
Okay. I got to ask you, does Social Security have like a special division to come up with acronyms? I mean, it's just like I've never done. I mean, and again, I'm used to them, but RFC, FCE, SGA, DLI, IRWI. I mean, it's like there's got to be some guy in an office someplace up in Washington, and his whole job is to come up with acronyms to make everybody confused. I'm convinced of that. I may be wrong. I'm convinced of that. Okay. Apparently, Greg, you have an echo. I guess I don't, but you have an echo. So I don't know if there's any way to deal with that echo on your end, Greg, but people are telling me that you have an echo in your microphone, Mr. Yoda. So I'm not sure what if anything you can do. Maybe
Yeah,
you have speakers maybe going on or something that's also.
Yeah, I put the headphones on, so
Okay.
that was a while back. So hopefully.
Okay, maybe that's not happening anymore. Okay, all right. So yeah, the minister of abbreviations. I'm sure that probably exists, but and one day I'm gonna get that person on this live stream, and we're gonna run through the ringer here.
Let me know too.
Yeah, absolutely. All right. If a judge asserts that the validity of an ALJ's opinion is in question, ALJ's is that code for the district court judge saying the ALJ should grant? Okay, so what this person's asking is that they went to appeal, and the appeals council or district court questioned the judge's decision. Is that sort of saying to the ALJ when it goes back to the ALJ, look, you screwed up, approve this case? Or is the ALJ, maybe the ALJ is a little tone deaf and doesn't get it? Any thoughts about that? I mean, do you maybe you don't even deal with this or didn't deal with this, but are ALJs, do they care what district court judges are saying to them?
Well, interestingly enough, the DDSs at times would handle remands.
Mm-hmm.
In terms of the processing of them and being able to assist in getting a CE or getting additional records on remand. So outside of that, I think that there could be the question of the ALJ's judgment that says, hey, we got a red flag here. This is not adding up. Mm-hmm. And when we looked at this at the appeals council, they said, well, no, we're not on board with this. And we're going to send it back and get it corrected.
Well, I had a case, and I've shared this with some of my colleagues, just the first couple pages of it. I had a case where it was a fibromyalgia case, went before a judge who's got a very low approval rate, got denied, not surprisingly, appealed it to the appeals council. I think it went to district court, and basically the district court sent it back saying to the judge, and it goes back to the same judge for some unknown reason, that you've got to take into consideration this person's subjective complaints, because fibromyalgia by definition is not something you can take an MRI or X-ray of. So the judge basically awarded the case, but wrote a footnote, I kid you not, that took 2 pages of the decision saying he's only approving this case because the district court is forcing him to. He doesn't believe this person's disabled, and the district court is full of crap. I mean, he literally said this. I mean, and needless to say, this is not one of my favorite judges, and I don't really like when I get cases in front of him, but he did grant the case. I'll give him that. But I mean, that situation, I suspect he gets appealed a lot because he denies a lot of cases, and as he should, because his decisions are not always well written. So, I guess
biased.
Yeah, no, this guy's terribly biased, terrible judge. I don't know why he became a judge, but, although I've seen somebody on this live stream who had this judge and won, so it can happen. That footnote is crazy. It's just, I've never seen a judge, just go after the district judge the way he did, but he did. So, okay. All right. On SSDI and turn 55 next month, can retire early and draw some monthly pension from a non-government job. Do I need to notify SSA? Would that be considered income? Okay, Greg, you can tell me what your take on this is.
Well, if you're getting retirement usually is not considered earned income because you're not doing something to generate that income. Earned income is when you're working and you're getting a check, or if you're self-employed, you're benefiting some way from your business through your own efforts. But if you are it's a non-government job and getting a monthly pension, that will not impact your SSDI benefits at all. There's no There's no offset involved in this situation.
Mm-hmm.
I think the only difference is if you know, maybe a teacher or something like that, which is technically still government in a way, but it doesn't sound like that's the case.
Mm-hmm.
So there shouldn't be any issue with you being able to get your full benefit from your pension and still get your SSDI.
Okay. And by the way, the one time that I've seen it can be a problem is there is a I'm drawing a blank on the name of it. It is a FERS, FERS, Federal Employee Retirement Services, and they will offset your Social Security 100% the first year and 60% the second year, I believe. But the problem is that if you win SSDI, the attorney's fees, obviously are part of that back benefit, 25% with a cap of $7,200 at present. FERS does not give you credit for the attorney's fees. So that means that they're going to offset the full amount, even though you didn't see that $7,200. Now, it's only for 1 year, but that always struck me as being really unfair. So my point is, if you've got a FERS retirement, you might want to ask some more questions. I'll just leave it at that, but that is potentially a problem. All right, John says, I worked on my approval process, made a little over allotted amount, had accommodations like nothing over 10 pounds, nothing overhead reaching, needed help from coworker. I don't know that is really a factor. I mean, if you are, you're on light duty essentially, but you're earning money over SGA, I don't think that is something that's going to necessarily protect you. I mean, the fact that you needed, you had a light duty limitations. If you're earning over SGA, you're earning over SGA, correct?
Absolutely. They don't really care about what you did at the job. They're looking strictly at what you did in your earned income and whether that's over that limit, because that's step one in the actual claim. Are you earning above SGA? If you are, the DDS is going to send the case right back to the field office and initiate a technical denial.
Yep. All right, Sherry Moonahan. I think Sherry's been on the live stream before. And I get this question a lot, both in my practice and on the live stream. I'm 100% permanent total disabled veteran, was denied SSDI. Is there a way I could still receive SSDI? They said I don't qualify due to not having enough work credits, but I have 40 credits, enough for retirement. So there's a lot of things going on here. One thing, and I'll take part one of it, is if you don't have the credits recently, even though you've got enough for retirement, you don't have enough for disability because it's not been recent. So that's part one. Part two, I'll ask Greg to answer, and that is, what is the relevance of, in a Social Security disability case of being 100% disabled vet?
Not much.
That's right. Not much at all.
Because we're dealing with two different entities.
Yep.
And VA's standard for disability is not SSA's standard for disability. The definitions are different. There's different criteria that you need to meet in order to be eligible for either one. So being 100% rated by the VA is excellent for the VA's purposes, but that doesn't translate over into an SSDI claim because Social Security has its own definition of disability that is different than the VA.
Yeah, and it's always struck me as just being absurd that you have two federal agencies, both administer disability policy, and they have different definitions of disability. But that's the way it is. Being 100% disabled by the VA will get you to the front of the line, though. You'll have a faster adjudication, and it certainly can help. I mean, I've had judges make reference to the medical records from the VA and the VA conclusions and the doctor's notes, but it doesn't automatically get you disability. I think in Sherry's case, the bigger problem is she doesn't have enough credits. And going back to what Greg was talking about before, is there a way to argue that your disability began during that window when you were insured? So this is where it would be wise to get a DISCO analysis or DISCO printout or DISCO explanation as to the period of time when you were actually insured for disability, and is there evidence to say, back in 2020 or 2021 when I was insured, that I was in fact disabled? Again, it's more difficult. because going back in time is more difficult. It's much more difficult to win a case when you're saying my disability began 5 years ago as opposed to it began 5 months ago. But, that may be what Sherry has to do. Or, Sherry or a person like this could go back to work theoretically if you're within a credit or two. Sometimes you need 20 credits and you're at 19 credits. Well, go back to work and you can earn up to 4 credits in a year, but you can earn them all in one day. So you could earn $8,000 in a month and you get 4 credits. So if you're real close, go back to work. Even if it's a struggle, but that would get you into SSDI land. And by the way, if you're getting veterans VA disability, that's going to take you out of SSI, possibility, because VA offsets SSI. It's an income that's going to make SSI not feasible. Okay, I think we've already talked about this. Could the DDS punt to the ALJ if there's a remand coming from federal court? There's a new claim. I think I understand what they're asking, but tell me how you read this, Greg.
Yeah, so it is possible for a person who is awaiting an ALJ decision to apply for another claim for SSDI. It can happen. I think that it is something that is not well known by the public that this is possible. And it's really an extreme situation. It's not something that is usually successful, in my opinion, because if you're getting to the ALJ already and you've been denied several times, filing a new claim would, in my mind, really require something new.
Something new, right?
A new impairment, or your impairment became more severe. But there was a at one point we were working on cases where this was a situation and people were applying again, and we needed to screen these cases out to see whether there was more severe impairments there. And if they were not, then they would not be processed.
Yeah, and I will tell you from my perspective, when somebody, I'll get emails, case evaluations, somebody says, I just got a denial, back in that, again, we're in July of 24 now. I got a denial in March, so it's past the time to appeal it. They've run their 2 months. And I want to reapply. And my response to them is, number one, realize when you reapply, the onset date is going to be the day after your unfavorable decision. So all the stuff that went on before is background. It's not going to hurt you, but it's not going to really be dispositive of anything. But more importantly, it's going to go to the same judge. And unless something is new, you've changed age categories. Now you're 55 when you were 54, or you have a brand new impairment, you're going to get the same result. I'm reluctant to take those cases because you're probably not going to win unless you've got something significant. Now, you had a heart attack, you had a stroke. Okay, that's something different. But if everything's just the same and you keep applying, you're going to get the same result. So, applying and it's not going to be that you're not going to wear them down by continuing to apply over and over and over if nothing has really changed. So.
And Jonathan, to add to that, in some cases, a person may do that and the listings may have changed.
Yep.
Or on the flip side, the technology in medical advancements has improved. So it could go either way. It could actually work in your favor if there's been a change in the listings that makes it more advantageous.
Although, counterpoint, have you ever seen a change in the listings to make it easier? I will leave it at that.
Very seldom.
Yeah, very seldom. How about never? All right, John comes back. We had dashed this before, where he was asking about needing help from coworkers and this impacted my duties. I did less. Again, what he's getting at is, does that count, towards SGA? And my understanding is Social Security is going to look at the earnings. Okay, so if you're over SGA, it doesn't matter if you're getting help from your coworkers, they're going to look at the number. So, you can't say, well, I'm earning, $5,000 a month, but I'm really not doing anything, but I'm getting help. I'm going to work, but my coworkers are doing everything for me. That's just not going to hold water. It's not my understanding, it's not really a rebuttable presumption. If you're over SGA, you're over SGA. And I think that, you don't have to, if you can be over SGA occasionally, so let's say you're working and, January, February, March, you're under SGA, April, you happen to be over by a few dollars. May, June, July, you're under. August, you're over. It's not gonna. They're not gonna say 1 month you're disqualified because you're over SGA 1 month. But if it's an ongoing pattern, am I seeing that correctly? That
Yeah.
you've got to be over SGA kind of on a continuous basis. But if you're over SGA and you're getting help, it doesn't matter. The being over SGA is the problem.
Yeah, and it actually, if you're earning significantly above SGA, no subsidy and no IRWI is going to help you get that under SGA.
Yeah.
It's more on the borderline cases where maybe you're over $300 or maybe $500, and a subsidy can say, okay, well, I was getting help from my coworker 60% of the time. Okay, that might do something to get you under SGA.
Yeah.
But if it's significantly above, there's not much you can do.
Not much you can do. And I think that, Social Security is going to be suspicious of somebody who's over SGA coming in and saying, well, I really wasn't doing anything, unless they weren't going to work. Now, I've had situations, I got one right now, where I have a client who stopped working in October of 2023. They paid her full salary through the end of December, but she stopped going into work October 3rd or 4th or whatever of 23. That's different because she wasn't doing anything. She wasn't going to work. She was getting paid. But if she was going into work and just sitting there, that's where it's more problematic and it becomes the facts and circumstances. And that's going to be hard to argue that you weren't really doing anything because most employers aren't going to pay you not just to sit there. And again, they may pay you, if you've got, accrued vacation time, things like that. But generally, that's not going to be something that goes on. All right, Jerry says, I filled out a work history form and they called me today and asked how I did it. I was self-employed. They asked if I had employees. I didn't. They asked me if I did invoices. I didn't. What do you think? So it sounds like Jerry was self-employed and kind of did everything. So, again, that sort of looks like SGA, does it not to you, Greg?
Yeah, it does. If you don't have any employees, if you're sole proprietorship, they're going to be using, I've just drew a blank on the term, but basically they're looking at the amount of effort that you put towards your job. What types of things you do in your job? Was it just you or did you have help? And if you were doing significant services, if you have significant services, then they would look at that as work and significant past relevant work.
Mm-hmm. Okay. All right. Here's a question. Elizabeth asks, I was denied my back pay from 2014 to 2019. Should I appeal it? Well, the question here is obviously, it depends on, when you applied. If you were denied back pay, but you applied in 2022 or 2023, and you alleged an onset date, back to whatever, 2010 for that matter, you only get paid 1 year prior to the date of application. So maybe the reason you didn't get your back pay was because your application date was, more than a year, before the time that you were supposed to get paid. So I don't think that there would be any grounds to appeal if you applied, in the last year or two. Correct?
Correct.
Yeah. Okay. Edward says, does contacting SSA either over the phone or in person raise your chances of a review? Best to let sleeping dogs lie, I'd guess. Probably why some of us here to ask you. I don't think that contacting SSA is going to raise your chances of a review. I mean, they're looking at, let's talk about reviews. We get a lot of questions about that. What would prompt a review, a continuing disability review?
Well, one thing is your diary expiring. So if
meaning what? What does that
your
mean?
medical diary is when you are allowed SSDI or even SSI for that matter, you receive a diary, which is the number of years you would wait until your case is actually coming up for review.
Now, you don't receive it means Social Security. Where's this? It's internal, correct?
It's internal and it's determined on the impairments, what the type of impairment it is, and in some cases the severity, whether it is an impairment that will be that can improve, something that is expected to improve, something that's possible for improvement, or something that is not expected to improve, which would be the longer diaries, a 7-year diary, when they're being allowed for the first time.
Yeah, and by the way, I had a client come in to see me the other day who has a short form review. Again, and this is a gentleman that will not be terminated because his condition is permanent. And he showed there's codes on the short form that you can, and I'll try to get a hold of that and kind of give you an interpretation. But there are codes that will tell you what how you're categorized. But is there any way for a person who just gets approved to know what they're categorized, how they're categorized? As far as okay.
Yes.
Tell me.
So in their electronic file,
okay,
there is a form called the 831, SSA 831.
Okay.
That is basically the decisional document that shows your the primary and secondary diagnoses. It'll show whether you were eligible for blind benefits. It will show the diary. It will show the diary expiration date. It will show your onset date. It will show the reason for the decision, which is one of the major things on that form. So if you met a listing, there's a code for that. If you were an allowance for vocational issues, there's a code for that. So the 831 is really it's probably the most important document next to the disability determination explanation.
How do you get the 831?
You would have to request your electronic folder.
Okay.
From the field office from Social Security.
Okay, so is that something that you need to do a Freedom of Information Act thing request on, or is there? I mean, how would you physically do it? Would you write them or contact them, or? I mean, it seems to me this is something that every disability recipient ought to do.
Mm-hmm. Right,
okay.
and more than likely, depending upon the field office that you're dealing with, they will not. They may not release it if there is not a legitimate reason for you to get it, per se. So if you were trying to appeal, then they say, yes, you were entitled to your electronic file in order to prepare for the next level.
Yeah. Okay. But
and attorneys would have access to that as well.
So I'm going to have to figure out a quick way to get that 831 for my clients, because I think that would be very useful information to have. But again, maybe Nosker can help with that. That's an interesting point. I did not know. I'd never heard that form number, so we shall see. Okay. St. Louis, Greg, do you think things got more strict and stringent between 2017 and 2021?
I don't know if I would say more stringent. I think with the pandemic specifically, that caused a lot of the fallout that we're seeing now in the DDSs. Because there's been, and Jonathan, I'm sure you know this, that there has been just a slow decline in the DDSs in terms of the salaries not being commensurate with the work, and people were saying, hey, I don't want to have to deal with all this stress if I'm not getting paid. And then compared with state and federal, the federal DDSs pay $20,000 more on average than the state DDSs, which is why a lot of people are trying to apply from the state DDSs to go to the regional offices.
Yeah. I read someplace where in some places you can make more at Starbucks than being in the DDS, and that's that they lose. And I think the VA also poaches people. I'm reading that too. VA poaches people. So it takes a year and a half to get them trained, I'm guessing, right? I think you told me that at one point.
Yeah, it takes six months training. Then there's a 6-month probationary period. And then it takes roughly between 2 and 4 years to really know how to do the job well. But the entry-level journeyman analysts are probably getting paid around the salary of a teacher.
Yeah, a lot more stress. Okay, here's one of my clients, Sean. Thank you. I remember talking to you. We had a long talk about barbecue. I remember. Um, okay, so if you are approved and you've got minor children, what is the step to take? Because many people, my experience has been most people when they apply, they don't apply for their dependents. They do it after they're approved. So tell me, what is the steps? What should someone like Sean do?
Well, when they apply for SSDI, they usually have to complete a section of the form that asks about dependents.
Right.
So that will already be on the application and in the system, because you have to report the children, the ages, and so on.
Mm-hmm.
When you are allowed SSDI, they will take that into account. They will look at your auxiliaries, and in this situation, children are considered auxiliaries, which means that you have dependent children, and they are going to be in need of something extra coming from Social Security to help you take care of your children as you have this disability.
Correct. Okay. All right. Freedom 1964 says, I was granted SSDI in November 23. There will award letters for review in 5 to 7 years. I'll be 60. November, do you think I might get reviewed? My experience has been, if you're over 55, are you going to really get reviewed? What do you think?
Well, just as an anecdotal situation, when I was at the DDS, I used to screen CDRs. And screening CDR is basically saying we would look at the case and see, okay, is this person over 55 or under 55? And if they were under 55, then more likely we're going to go to the CDR. If they were over 55, then we would say, okay, we need to screen this out, because the likelihood of this person being able to need a full medical CDR is far less.
Yeah, I would think they're going after people in their 30s and 40s that are more of a drain on the fund, that more likely to have improvement too.
Yeah. And even those who are, I talk about this in one of my videos, when they have a specific diary, a MIND diary, which the MIND stands for medical improvement not expected. When they have that kind of diary and they are over the age of 51 and a half, then they're likely not going to see a full medical CDR because of the nature of the impairment.
Mm-hmm.
When the diary expires, they'll be even older than they are at that moment.
Yeah. And when you talk about a diary, that's kind of like a to-do list, is that, or sort of a tickler system, a reminder to check it. Yeah.
It kind of works that way, because the number of years to wait for the CDR.
Okay. Just when people think of diary, they're thinking, right, dear diary, Bobby is so dreamy, that kind of stuff. That's not the same kind of diary. Okay. All right. Crystal says, I was scheduled for a mental exam by Social Security. This is my second time and reconsideration. Why would Social Security send somebody out for a second consultative evaluation?
That's a good question. One reason why is because when you deal with mental issues, they may be trying to assess the severity if there's a gap from that last CE. So are your symptoms still severe now than they were at that previous CE? It also could be just trying to resolve an inconsistency they may have found in the process of your recon. So if your record is showing something, and say, I don't know about this, and the CE report showing this, it seems pretty bad. But we get this, okay, let's get another CE just to clarify, okay, maybe there is some consistency here. We just need to make sure that there's consistency in this severity.
True or false, and my impression is that physical consultative evaluations are, almost useless. Mental health ones have more value. What's your take?
It would depend on the type of physical. CE. I would say if I were to rank physical CEs, the most valuable ones would be, I would say neuro and cardio would be tied for first.
Okay. But I mean, the ones I see a lot are the general ones they send into an industrial clinic. And these are the insurance companies use to deny claims. And half the time they don't say anything. They just repeat the person's allegations, and or they'll say there's no limitations or something like that. I find them usually pretty useless. That's been my experience. Although the psychological ones are usually practicing psychologists who will usually find something I can use.
Yeah, but I've also seen psychological CEs and psychiatric CEs that were not very well done.
Yeah,
I know
it's
you
almost
have
like
too.
Yeah, it's almost like some of these that don't have training. They don't know what they're supposed to be talking about.
Right. But on average, they are more valuable than the physical ones.
Yeah.
But there are some valuable physical ones. Neuro is very
especially if
cardio,
it's a specialist. No, I mean, if it's a cardiologist, neuropsychiatrist, something like that. But if it's just your general, not always, but many times it's not.
Yeah.
There's actually a gentleman, I'm drawing a blank on his name, who's got a YouTube channel. Guy wears a bow tie. And I've talked to him a couple of times. Who I'm talking about. And he is a medical doctor, does consultative evaluations. And he's got some really interesting things to say. So I'll see if I can't remember his name off the top of my head, but there is just type in YouTube, consultative evaluation, doctor, Social Security, and he'll come up. But he puts a lot of good stuff out there. So worth looking. Okay. Main events. I filed for SSDI 19, approved in 2022 at age 50 because of the grid rule, not uncommon. Didn't use an attorney, got zero back pay. The process was exhausting. My comment on that is I have a lot of cases where, if the person's 48, 49 and we file it, SSA will many times approve the case, but they change the onset date to the 50th birthday to meet the grid rule, and there are no past due benefits. And, it's a tough call. Do you appeal that? Do you, bird in the hands worth two in the bush? Do you appeal a favorable decision that cuts out your back pay, or do you roll the dice and say, I want to go in front of the judge and argue that I should be entitled to the back pay? My rule of thumb is, if you don't have the tolerance for risk, take what they're giving you. But, if you're willing to roll the dice, the fact that they approved you, is a pretty good sign that it's not likely, in my opinion, that a judge would then turn around and deny your case. Maybe you get the same thing, but, if you're willing to wait, a couple of years, then why not give it a shot? What's your take?
Yeah, I agree. It sounds like it is a borderline age issue that he was dealing with, and they made the decision that you were not able to meet the standard for a MedVoc allowance until you got to the next age category.
Right, 50, right.
Yeah. So actually my next video is dealing with that particular situation about partially favorable allowances, and I talk about that very thing.
Yeah. What is and if you do that, if let's say they grant you, but they change the date and you appeal it, do you get your benefits while you appeal?
It depends.
I've heard different things. Yeah.
It depends. If you have a partially favorable, going to get a sneak preview of the video.
Yeah.
So if you have a partially favorable allowance, you can appeal that, and I believe they can effectuate payments, but I don't know if it's something consistent, because here's the thing. And I talk about this in the video too.
Okay.
If you appeal a change of onset and that case comes back as a recon to the DDS,
right,
there is a chance that decision can be reversed.
Oh yeah. You could be denied. It's a de novo. Yeah, they could look, and at a hearing, it's de novo. It's a whole new review. You can get a bad judge, and you're out of luck.
Right.
Now you can bankrupt on if let's say they overpay, you can bankrupt on that. Not that that's what you want to be doing, but it's I have a couple of cases right now where by changing the onset date, my client lost $30,000 of past due benefits. And, I'm thinking that's probably worth rolling the dice on. And by the way, as an attorney, there are situations where if they choose not to appeal it, I don't get paid because of the 5-month waiting period and so forth. And quite frankly, that's unfortunately the way it goes. I mean, there is as an attorney, we have an obligation to do what's best for our clients. And so I always tell my client, you do what's best for you. I mean, yeah, I want to get paid, but on the other hand, you got to do what's best for you. And I would never tell somebody to appeal if it was risky, simply because I want to try to figure out a way to get paid. It's just the way it goes. So, your attorney should not be basing advice about whether to appeal a partially favorable decision based on what's his or her financial needs are. It's based on what's important to you, right, what's relevant to you.
But I will add, Jonathan, real quick, is that there is a situation where they can get benefits effectuated in that situation, and that is if the DDS can see that there's a potential for an earlier onset.
Okay. And what would you do? So would you make that allegation in the recon appeal?
No, it wouldn't even be an appeal situation. This would be a DDS action.
Yeah.
Where the DDS says, okay, this person is on allowance. We know this from this date, which is not fully favorable. But we can see in the records that if we develop it some more, we could actually give them an earlier onset. So we'll send the case back to the field office and say, hey, put this person in pay.
Yeah. And
then send the case back to us so we can continue and develop whether this person actually has an earlier onset, which could be advantageous.
Okay. This is a question. I don't think there's really any way to really answer it. What state is easier defining a disability? It's going to depend on your case. There's no, you can't say. All right, cancer free. Okay, thank you both. You're welcome. And at what age does SSDI turn to regular Social Security? Full retirement, correct?
Yeah, when you hit your full retirement age.
Yeah. Okay, all right, so you did fix the echo. You got to thank you there. Okay, I think we've already answered this. How much money can you make each month extra safely? Again, well, maybe we addressed this before or not. If a person is earning, 1550 is SGA, and the person is earning 1,549 month after month, is that, you're telling me that's not going to be a red flag?
Not in general, because they're going to take that person's report, and when the person completes the work activity form, right after the application, Social Security is going to have an idea of what their SGA is going to be like, and they can make some judgments on whether this actually meets the standard for SGA.
Okay. So again, I wonder sometimes, where, because again, people are really concerned about getting reviewed. I've always told people, when you're working, $1,300, $1,400 a month, I don't think is a real problem. I would personally be concerned about earning right at SGA, but again, it may be that they're not allowed to even consider that. Look, it's the same issue that runs in hearings. People say, well, judges are not supposed to look at your social media profile. I still tell people, put your social media profile on private. Don't have your Facebook page open. I remember one time I had a client, and it was not a particularly good case, but I looked at her Facebook page and it shows her climbing a rock climbing wall, and she's saying that she got orthopedic issues. I'm like, I just don't think that's a smart thing to do, but that's just.
And that will be cause for CDI to step in.
Right, exactly.
Fraud.
Okay. Okay. I have concurrent cases with lump sum coming. The attorneys got paid, but when I call the local office, they give me the runaround processing the case. This is again where you have the SSI part. You've got to go through that interview. I've had people sometimes not participate in the interview, or they need more information. I had one case where a person was a green card holder. They wanted to see original documents. There's obviously some holdup there. And I would say your attorney needs to look into what the holdup was, and or reach out to your U.S. Senator's office and see if they can help with that. Let me ask you, Greg, when you were working for Social Security, what was the effect of a congressional inquiry? U.S. Senator, Representative inquires on behalf of a constituent. What did that mean?
That's a great question. So what that would mean for the DDS is this is high alert.
Mm-hmm.
Now, whenever you get a congressional inquiry case, which was not that frequent, we looked at it as a high priority case, because now this becomes a public affairs, a public just drawing a blank on a term. It's a public affairs issue.
Mm-hmm.
This is something that's going to become, it could become larger.
Right, bad publicity for the agency.
Bad publicity,
Yeah.
yes. So they wanted to take that case and make sure that it got special attention.
Yeah. Well, I suspect also that, Social Security gets its funding from Congress, and so, they need votes. I mean, if they're trying to get more money or any number of things. So yeah, they're going to pay attention. I've always understood it that, you get a letter from the congressperson, that speed things along. And I've seen situations where they report back, we made this decision, this is what's going on. So, I think it's, if you, it's wise to use your congressperson. That's why they're getting paid. They're your congressperson. They're representing you. I wouldn't necessarily file an application that a week later go to your congressperson. Given the fact that it can take 8 or 9 months to get a decision. At initial, let's say that 5 or 6 months in, then maybe that's when you do it. But don't do it. Don't abuse it. Is my point. It's going to have to be something where they're going to realize, okay, there's a problem here.
Talking about extreme cases here.
Yep. Okay. This is an interesting question. I talked with a disability lawyer, and I thought at the time maybe I should go through a lawyer. That was back in February of this year. Never did an application with him. He never did it for me. When you talk to a lawyer, you've got to sign paperwork. Talking to a lawyer doesn't mean you're represented, and the lawyer should make it clear. But you should be signing a contract, a fee contract, which basically talks about you're agreeing to pay 25% of your past due benefits with a cap, which, by the way, is $7,200 now. It's going to go to $9,200 in November. So you got to sign a contract. And the second thing is you've got to sign something called a Form 1696, which is an appointment of representative form. You don't sign that, you're not represented. So, you want to make sure you're really clear with your lawyer that he is or she has agreed to represent you, and talking to a lawyer is not the same as being represented by a lawyer. So, this is especially important if you have a deadline coming up, for an appeal. I always have I have language in my letters. If, let's say, somebody contacts me about a recon appeal and I don't think it's a case that I can win, it's not something I'm interested in, I'll make it very clear. Look, I'm not taking your case, but you got 60 days from the date of the denial notice plus 5 days for mailing, or 65 days. You got to file something. And I'll usually give them a link to the appeal notice. But you can't until you've been retained, you've retained a lawyer with a signed contract. You're not represented. So don't assume otherwise. And I've had people call me literally that said, "Well, I hired a lawyer 7 years ago. I haven't heard anything." Well, it's delayed, but it's not 7 years delayed. So if you don't hear something, you should be hearing things pretty regularly, whether it's mail from Social Security, communication from your lawyer. We just started this week, a new system in my case we use to manage our clients. We added a texting feature to it. And so now whenever something happens, my clients get a text as well as an email. So it's just, you want to keep people, involved in it. But if you're not hearing anything from anybody, that's a big red flag. You got to get on the phone and say, "Hey, what's going on? What's going on?" Okay. Let's see. I was diagnosed with degenerative disc disease, the ankylosing spondylitis, and spinal narrowing, along with bilateral stenosis. Is that a good chance? Again, Johnny, diagnosis does not mean approval. You've got things going on here, but the question is, how severe are they, and what is the practical impact on your capacity for work? These diagnoses suggest something fairly serious, but again, people work with herniated disc. People work with stenosis. that doesn't win or lose the case. It's what the effect is, what the medication side effects are, that sort of thing. All right. Okay. Once your case is approved, where does your file go? I don't know. Where does it go? Into some sort of a warehouse someplace where they keep the Ark of the Covenant on one side and Social Security files on the other? Is that,
All right. So back in the days of paper, when a case was allowed, it would go into what's called the caves. These were literal caves.
Yeah.
And these are associated with the different payment centers, processing centers around the country. So some would be in the field offices, but a lot of times they would go into the caves because there would be no need to house them in a physical location because there'll be years to wait to bring that case back up. Now we're in an electronic environment. Everything's online. Everything's like in an electronic folder.
Right.
So every time you file a claim, it's going to show in what's called eView or EDCS. It's electronic disability.
Another acronym by that guy in Washington. Okay.
That dude, right? Exactly. So every time you file, there's going to be a record in your electronic folder, and it's always accessible. So if there's a need to reopen the case or look at a prior file, it's right there.
Yep. So the paper parts are shredded, and everything's kind of gone electric. And I will give Social Security credit on that because we talked about this, mentioned this before, but back in the bad old days, we had paper files, and there were these huge yellow cardboard files that we would have 6-part files, and literally to review a file, I'd have to go down to the office, the hearing office, sit there in a waiting room with my laptop and review the file, or a notepad and review the file. Much easier now. It's all done electronically. So,
and Jonathan, you were not the one working on the claim, so you didn't have the worst of it.
Yeah, no, I'm sure. I mean, it was bad. All right, just to get back to Daryl, mixed answers about how much you can make. Okay, the legal answer is you can earn up to the SGA amount of $1,550, which is 2024 numbers, and that is technically, okay. And Greg's position is that earning up until that limit is not going to increase the chances of review.
All right,
I'm of the opinion. Well,
now I want to add something to that, because if you are under that, well, here, let me do it this way. There's what's called a work CDR. A work CDR is when they're actually looking at earnings that you earn while you are SSDI.
Okay.
Now, when you are working and you're reporting your earnings, and they see, okay, you have some months where you're above and below, what they can do in work CDRs is average your earnings. And they can say, well, on a particular a certain span of months, or maybe over a year, they can say, okay, on average, he was under SGA. So even if you were $1 over, or maybe even $100 over, they have a way to just average that out and say, okay, we're going to look at this. Okay, was he under SGA on average for this particular span of time? If he is, then we're not going to count that as a month where you'll be ceased in your benefits.
Okay. All right. Let's see here. So I still say, though, I mean, to answer Daryl's question, you can earn up to $1,500, $1,550. I'm of the opinion that it's safer to be a little bit below that.
Yes.
But arguably, you could earn right up to that. So I would still tell you, try to keep your earnings somehow in that, or $1,400. That's probably safer. I'll just leave it at that.
It's just to err on the side of caution. Yes.
Yeah, err on the side of caution. Okay. I like this. Doug says, 2 powerhouses coming together to help the masses. Okay, I've been called many things. In fact, I've been called some things on this live stream that I blocked the people for calling me. Some trolls around here. We've blocked them, but I'll take powerhouse. So, I play tennis. No one's ever called me a tennis powerhouse, but I'll take powerhouse. Okay.
Doug is one of my clients, and he was just allowed for SSDI after on the recon.
Awesome.
So we were rocking for a whole year. We got him on. So, I'm glad that he was able to cross over.
Okay, cool. All right, Donna says, recon's going on 21 months. Is that normal?
No, it's not. And Donna and I have been communicating on comments on my channel.
Okay.
And her situation with her husband is a very outlandish one where they've been waiting for a long time for a recon, which is out of the ordinary. Jonathan, I'm sure you know that back when in the bad / good, whatever old days, recons were far shorter in processing time than initial.
Yeah.
I could finish a recon in 2 months or less. This tells you the landscape that we are in with Social Security disability. When a recon lasts this long, this something that's completely wrong.
Well, I mean, I give the new commissioner credit, and he basically put an end to CDRs through the end of, I think, September.
Yeah.
And he spoke to us at this convention. He's like, we got a problem. We don't have enough people. We don't have enough funding. And he knows it. And, but there's still a human cost when somebody has to wait, for a recon for almost 2 years. That's absurd. That's where I would say you go to your congressperson and say, congressional inquiry. Yeah.
Yes. And Donna, I recommend that, Donna. This is a time to contact your congressman.
Yep. Okay, so we're getting close. We've got 15 more minutes, so we're kind of zoom through some of these. Just Sam, the man, went through a CE exam. The doctor had a Russian accent, was very rude, refused to look at MRIs. Exam took 10 minutes. I'm not very helpful. What I would do is I would, try to write down as much as you can remember about that exam, and make sure your lawyer has it, so that at the hearing, your lawyer can ask you about that. And you can try to ask the judge to give that CE exam very, very little weight. Because obviously, you're at least, what you're telling me is that you didn't get a very fair exam. And I think, you can certainly put that into issue so the judge can have something to think about. Actually, one of my colleagues, and I think I've got it someplace, he has, I think it's Michael Liner is his name, who's another disability attorney, has a really nice practice, spoke very, very eloquently at the NOSCR seminar. He has a form, and he sent it to me about, what somebody should fill out after a CE exam, just for their own purposes, and to give it to their attorney, because, if you have a CE exam that was not helpful, you need to address that. And again, if you can talk about, you weren't treated fairly, it lasted 5 minutes, the doctor didn't say anything to you, you could, I'm not saying the judge is going to necessarily honor that, but it gives you at least an argument there. So that's what I would say about that, just to take notes and let your attorney know about that.
Let the examiner know too, because
that's a good point. Let the examiner know.
Yeah, they can research that and see if he needs to be taken off the panel.
Okay. All right, so EJ, is this one of your clients too? The man, the myth, the legend? Because
I think that's you.
That's me. Okay, well, my wife would say I'm the myth. I would definitely say that. So, you're not the legend. All right, let's see. Okay, here is appealed twice, lost the last case with the judge, a little approval rate. Judge denied me, went to federal court, appeal a third time, got the same judge and won. So there's hope. Okay, well, great. Calvin, I'm a nurse practitioner filling out my functional report that helped my case. I think a nurse practitioner is considered an acceptable medical source. So yeah, absolutely. Vincent, you are late to you are very late, Vincent. You're supposed to be here at 8:30 Eastern. It is, you joined at 9:11. So
come on, Vince.
Come on, Vincent. Next time, mark your calendar, set it on your phone. Don't want to see you late next time. Okay, Dwight, I had to leave my truck diving job at 26 years. I'll be 63 in August, been collecting SSA, some income. Okay, raises another question, or another point, and that is Dwight is getting early retirement, which is going to be a discount, typically 75, 80% of what he would get at full retirement. He's applying for disability. So if he wins disability, it's going to be bumped up to full retirement, essentially.
Yes.
He may have trouble getting a lawyer, though, because the lawyer gets paid based on the disability benefits. So if you're getting, let's say, I'll just use a number, $2,000 in early retirement, and your full retirement or Social Security SSDI is, $2,400, that's $400 a month difference. Well, if your case gets approved in a year, $400 times 12 months, the attorney's going to not get paid very much relative to other cases. So, it sounds like a good case, but don't be surprised if you're already getting benefits, you're trying to get, SSDI to get more, you may have a difficult time finding an attorney to take it.
Mm-hmm.
So, okay, let's see. Bipolar, is it a common one? And bipolar is somewhat common. It's again a disorder, a mental health disorder that can be, kind of, I guess, in the general area, depression, anxiety, PTSD, bipolar, fairly common. And, it's got to be severe. You've got to have the severe lows, severe manic stages. You've got to have evidence of multiple failed medication trials, things like that. I mean, do you find, I gave you my criteria, Greg, about mental health cases. Do you agree? Does it have to be at that level? Hospitalizations, suicide attempts, failed medication trials? What's your take?
Well, I think hospitalizations can help. I think there is situations where bipolar, where if you are in an inpatient, not being, but intensive outpatient program, that would be significant. If you have failed multiple medical medications, definitely. If your bipolar is significant to the point where it gets into the B criteria of the listing, which dealing with social interaction, concentration, persisting at a job, maintaining pace at the job, and drawing a blank.
Emotional stability and I'm guessing
interacting with supervisors and co-workers,
persistence, pace, stability,
concentration. So those things, if they are at a market level, that would be enough to meet a listing. But I would say in most cases, the bipolar could be enough for an adverse mental RFC.
Okay. Or one that would help your case.
Yeah, but it depends on, again, you're saying evidence is really the key.
Okay. All right. So Toy Head Ventures, hurt my back, not working, but still employed, applying for SSDI. My employer is filing short-term disability. Want to be notified if you apply for SSDI. Most long-term and short-term disability companies, if it's company provided, they will require you to apply for disability. If you're approved, you got to pay them back for any month you got both, but they don't make you pay back the attorney's fees. So in many cases, that means that they're picking up the attorney's fees. So if I have somebody who's got long-term and short-term disability, they're being paid. A, that's a good sign that they got picked up by an insurance company, but B, it's not going to cost them anything to have me do it. And a lot of these companies have non-attorney reps work for them. Sometimes they do okay, sometimes they don't. You can choose to have your own person. Most of the non-attorney reps will back off if I get involved in it. Some of those long-term disability companies have hired me to try cases for them. That's usually a pretty good sign. It doesn't matter, you're still technically employed. What's relevant is you're not physically going into work. Okay, I'm going to zoom through the last few because we're getting close on time. Sheila says, what about multiple sclerosis with neurocognitive disorder? Again, you don't win on a diagnosis, but that's pretty serious. And I look at every multiple sclerosis case very closely. If you've got neurocognitive disorder, that says it's pretty severe. That's gut feeling tells me that's probably a pretty good case.
I agree.
Okay. Greg, does SSI look not to approve on a date less insured because of the back pay? So is there a motivation? It looks like what Christine is asking, to try to get people to try to, for lack of better terms, get them or not say cheat them out of, but prevent them from collecting back pay? Or do they just look at it purely in terms of this is a viable case, this is what I can defend to my superiors as far as approving a case? Does the money come into play is what I guess we're asking?
No, okay. They're not concerned about the money. They're concerned about the medical evidence and whether you have enough to establish a severe impairment before your DLI ends, your date last insured.
Okay. Let's see, a couple more here. All right, Platinum Swords. I think wait times for determination is ridiculous. It's worse in Florida. National website says 290, even Florida is 389. Yeah, I think that, you get beyond 5 or 6 months. I think you reach out to Senator Rubio, one of your elected representatives, and say, congressional inquiry, this is taking way too long. I'm suffering. And these folks, you elected them, or whether you voted for them or not, they're your representative. Let them do their job. Let them help you. Okay, I'm 53, VA 100%. Will I benefit from the grid? It depends. It depends on what the medical problem is. If it's depression, no, the grid rules won't really apply. They apply if you've got limitations on your physical capacity. At 53, you're going to have to pretty much be limited to sedentary work for the grids to apply. And look at gridrules.net, and then look at the sedentary. Look at the grids for people at age 50 to 53, and maybe so. Let's see here. Dwight, I think we've talked to Dwight before. Okay, I think we already talked about that. Yeah, I think you've got a pretty good argument here. Okay. This is an interesting question here. Does SSI take into consideration if the person is approved under state of California? I think it's called EDI for a year. Would that help their disability case, or is it like the VA?
EDD is in California, and that wouldn't really matter much because we're talking about short-term disability through EDD. So, and I'm from California. That's how I know about this.
Okay.
So that would not make a person disabled under SSDI. What makes you disabled under SSDI is meeting Social Security's definition of disability.
Okay.
That's what we'll do.
Okay. All right. Luca Brasi, and I loved you in The Godfather, by the way. It's a great movie. Can you explain the difference between SSDI and SSI? One is based on your earnings, which you pay to the system. SSI, if you don't have enough earnings, it's essentially a benefit that's based on, you're saying the standard of disability, but you don't have to have earnings. And if you look at my website, go to forsocialsecuritydisability.com, and there's on the FAQ, there's a specific definition of what the difference is, or go to my website or Greg's website and just type in difference between SSDI and SSI. Okay, let's see, we're getting close here. All right, Jeff and Darlene, they've been on before, 407 days in Texas. Again, I think I said to you last week, Jeff or Darlene, congressional inquiry. Let's see here. Okay, we're getting close to the end. Okay, had my hearing on June of 24. I'm still waiting for an answer. Is this indicative of? No, it doesn't mean anything. I mean, it can take 2 weeks to 6 months to get a decision. They have decision writers, and the writers basically are the ones who have to process the files, and if they're behind, it can take longer. I have cases I've been waiting on for 5 or 6 months. It just depends on how busy the writers are. But the length of time that you wait for decision is not there's no relationship between that and whether you get approved or not. Okay, all right, I'm gonna take one more question, then we're gonna kind of wrap this up. Rex says, my application was at 90%, but then went down to 85%. They're talking about the online, they go to My Social Security. There's an online meter, as it were, that gets, percentages of completeness. Does that mean anything?
In my opinion, it means nothing, because
that's what I thought too.
There's no way for a system to be able to quantify how long a case is going to take, especially at the DDS.
Yep, absolutely. Okay, let me ask this one question, because I think there's some misunderstanding. If the work requirements are changing from 15 years to 5 years, how do you make the credits? I think you're misunderstanding what the change is. The change is basically they're looking back in terms of your past relevant work. The last 5 years is only going to be considered relevant for determining what skills you might have acquired. Your credits based on how much you worked. Nothing to do with your past relevant work and what Social Security is going to look at to determine skills you may have acquired. So one's about skills, one's about gaining credits. Okay, let's see if there's anything else we can get to quick. William, let's see, we'll go to this one. Okay, won my case. Okay, well, I'm glad. Well, yeah, that's right. We won back in 2022. I may have a review coming up. Not sure when I'll receive it. How should you prepare for a review? Let's make that our last question. How does one prepare for a review, if you can prepare at all? CDR.
It's a CDR. There's not really anything you need to prepare for, because it's really going to be looking at what's called a comparative point decision. So they're going to look at where you were when you were allowed, and then they're going to get updated records on where you are now, and they're going to compare and see if you have significantly improved medically. If you have not medically improved significantly, then you stay on the rolls. If you have, then they figure out, okay, can you do work based on what you have? So there's nothing that you need to prepare for. It's just a fact of the system. When you're up for review, the full medical review, you're going to go through this process.
Okay. All right. So I think we've hit our 2 hours. Greg, tell everybody how they can find you. I know you've got a YouTube channel, you've got a website, but tell them how they can find you, how they can reach out to you if they have any questions.
Sure. So I have a YouTube channel, the Disability Yoda with 2 A's, and you'll find me there. I have a lot of videos, not as many as Jonathan. Jonathan's he's been at this for a while, but I'm building. So I have about 70 videos now. So that's where you can reach me. Also, you can go to gregbrinkley.org, where you see my book, The 10 Disability Commandments. And if you are in need of any kind of review, you can go to gregbrinkley.org/Yoda-case-review. And I will tell you your chances of getting SSDI. I'll give you a percentage. Okay. So those are the ways to get around.
Okay, and I assume the disability Yoda. Well, Yoda was a Star Wars character. Is that right? For those,
yes. But Yoda stands for your on-point disability authority and advisor.
Okay, well, I like it. So, but yeah, Yoda. That if those who are old enough may remember Star Wars, you had a character named Yoda who was all-knowing and all-seeing, kind of like Greg. So I think it's appropriate in different levels. So anyway, I appreciate, as does Greg, everybody's visiting with us tonight. We will, we'll do this again, hopefully very shortly. And I really appreciate, Greg, you taking the time to offer your expertise and experience, because I learned some things. We're going to make some changes in the way I do it, because like I said, there's just stuff that you don't know when you're doing it on this side. As an attorney, I'm trying to get cases approved, but you're seeing it on the back end, and I think it's very valuable to have that insight. So thank you very much for visiting with me and staying with me tonight, all these 2 hours, and we'll do it again very, very soon.
Absolutely. Thanks, John, for having me, and always learning from you too.
Okay, man. You got it. Well, take care. We'll talk soon. Take care.